Hi, and welcome to Property Law 101. I'm Sara Bronin, and I created the series to help you understand the basics of property law. We cover 4 fundamental questions about property and property law, and today we are talking about the 4th, holding interests in property. So the first case which really brought regulatory takings to the fore is the topic of our video today. It was the 1922 U.S. Supreme Court case of Pennsylvania Coal Company versus Mahon. The facts center around the city of Scranton in northeastern Pennsylvania, home of President Joe Biden and the television show The Office. In the first half of the 20th century, Scranton was booming, the heart of the anthracite coal industry. So coal mining is very dirty, very dangerous. Depending on the geology, it can be done either on the surface or underground. If the mining is to be done underground, a mining company might own a mineral or underground estate only and leave the surface estate to someone else. So that's the context for where we are. And that's what happened in this case. In 1878, the Pennsylvania Coal Company granted to an individual, H.J. Mann, a surface estate to a parcel of land. He builds a house on the surface estate. Meanwhile, the company retains the right to mine underneath the property for anthracite coal. Again, this was a common practice. We're in the heart of coal country now at that time. But the coal companies there were not so careful. There were some very public cases of subsidence, meaning mining leading to the caving in of the surface estate. One situation in 1909 resulted in the subsidence of a schoolhouse in West Scranton. Concerned citizens started to lobby the state legislature, and in 1921, the state passed the Kohler Act. It forbade mining in any way that would cause the land under human habitation to subside. Around that time, the Pennsylvania Coal Company told Mann that they were about to start mining, and Mann says, "I don't think so." He brings a suit under the Kohler Act. The company then says, in response, this statute is unconstitutional. It effectively takes our mining rights away, our property interest, essentially. So going back to the takings clause, nor shall private property be taken without just compensation. In revisiting the facts, let's set out the test that the court establishes. While property may be regulated to a certain extent, this is a quote, if regulation goes too far, it will be recognized as a taking. Clear? I don't think so. So when does a regulation go too far? Well, we see here the court says this one goes too far. So let's think about why. A couple of reasons. So first, the court says there's not even a public use to this statute. It affects only a limited number of private houses. The court says that this is not even a taking as a result. Moreover, the court says that this regulation, the Kohler Act, which again forbids mining in areas underneath human habitation in any way that would cause subsidence, the court says that the Kohler Act would have a significant effect on the coal industry. And the court says it would make it commercially impractical to mine certain areas for coal. And because of that, it has nearly the same effects of completely destroying the coal industry. Now that's close to a quote, but not exactly, but you can find that language in the case. So the court says for these couple of reasons, the law is unconstitutional and it has to be invalidated. Now we get though to a very powerful and widely referenced dissent in this case by Justice Brandeis. So Brandeis argues that there is a public reason for this statute. He says, obviously, preventing subsidence is preventing a public nuisance. In other videos, we discuss what a nuisance is and also talk about how public nuisances can be defined by statute. Brandeis brings up other parts of the law, like the protection of public buildings, of streets, bridges, and utility lines, all of which are public purposes. In formulating the public nuisance exception, he says that government can prohibit even without compensation, uses of property that seriously threaten the public welfare. We'll see in the later cases whether the nuisance prevention rationale justifies other findings by the court. There's another issue raised by the majority that I want to bring up before we close, and that was the idea of reciprocity of advantage. With the Kohler Act, the court says that mining companies aren't even getting the reciprocity of advantage, which they found was important in another case challenging a mining law. They actually upheld the law in that case, Plymouth Coal, because the mining companies were advantaged by the law, according to the court, because the companies had safer mines and fewer accidents. So the claim here by the majority is that the Kohler Act is different. But I ask you whether this was the case. Certainly, they would have less liability if they weren't mining under houses that then were consumed by the earth. Justice Brandeis says the reciprocity advantage shouldn't even be a factor in cases like these, which relate to public nuisance and public safety. So I just flagged this issue for you because it does come up in another case that we're considering. So finally, I want to talk about the denominator. As we have discussed in other videos, we have to understand what the property actually encompasses before we understand whether property is taken at all. So Justices Holmes and Brandeis differ over how we should be thinking about the denominator. Holmes thought it was the pillar of coal that had to remain in place pursuant to the regulation, but which could have been mined in the absence of the regulation. Brandeis, meanwhile, thought the denominator was the entire interest in the subsurface estate. This makes a difference because it relates how much property is taken. We'll talk about the denominator more in two videos, one about the Lucas case and one called The Search for the Denominator. Okay, so what happens next? So after the Kohler Act was declared unconstitutional, mining companies generally appeared to abide by the agreements they had made about mining and subsidence before the law passed. One scholar, Bill Fischel, tells us that mining companies tended to be pretty good corporate neighbors. They paid out compensation to any injured property owners for a period. However, by the time the mid-20th century rolled around, mine subsidence and abandoned mines started to increase. Cave-ins sometimes consumed entire blocks of homes. Probably the Kohler Act would have been a good idea as mining companies failed and were unable to pay burdened homeowners. So thinking back, thinking to the Scranton of today, even bigger picture, it's a lot different from the Scranton of during the era of the case, which again was booming. Per capita income, as I sit here today, is $29,000. The population was half what it was 60 years ago. I really do wonder whether things might have been different if leaders were able to use takings law not to protect corporate interests, but to protect individual property owners who may not have known what they were signing when they signed the kinds of agreements that man did. So with that, I will leave it there. I would love to hear from you, whether on Twitter or through my website, where you can sign up through to my mailing list, and I will see you next time.